welcome everybody. Thank you for joining us on this edition of IPWatchdog Unleashed. This week, we're joined by András Jókúti, who is the Director for the Patent Technology Law Division at the World Intellectual Property Organization, better known as WIPO. András, thanks for being here.
Thank you, Gene. It's always a pleasure.
So the reason I invited you to speak today specifically, I know we've spoken in the past, and I know you recently came to Live. We really appreciate you being there and updating us. And when you were here at Live, you were talking about trade secrets, but I think you're on to a new initiative, one that has been something that we've followed at IPWatchdog for a very long time. I'll just give you the floor to tell people what it is that you're working on these days, and we'll go from there.
Okay, super. Thank you, Gene, and thank you for the opportunity. So we are in the middle of implementing a 3-year strategy on standard essential patents at WIPO. As you said, it's a relatively new area for WIPO to step into, which doesn't mean that SEPs were not mentioned before, but this is the first time that there is an actual structured, published WIPO SEP strategy. We published it last year in April. As I mentioned, it's a 3-year strategy going until the end of 26, which doesn't mean that we will not continue activities beyond that time frame. But this is the initial 3 years when we will actually see what's working less, and what we should continue beyond 26. And now we are kind of at the midterm of the implementation of the strategy. And I'm very happy to share a couple of that we have been delivering so far under the strategy, and a couple of things that are coming up.
So let me just ask you very basically, why did WIPO at this moment in time decide to get involved with standard essential patents? And that's probably not the right way to say it, right? I don't want to say like you had, it's not that WIPO has not been involved. I mean, you watch all things patents, all things intellectual property. But I sense, based on your answer and based on what I know leading up to this conversation, that WIPO is jumping in with both feet in a way that you haven't done before on this particular issue. So what makes it the right time? What's going on unique that made you guys want to get involved today?
I think it's mostly the realization that we just simply cannot stay away from it. It's a patent law issue, of course, on the crossroads of patent law and many other things such as competition law, of course, standardization, even some civil law matters as well. But it's not only a patent law issue, but also a global issue. Licensing of SEPs does not stop at the national borders. And even though patent laws or patent rights are territorial, licensing of SEPs is not. So as an international organization dealing with patents, we just realized that there are things that we could actually do, not only in the framework of the Standing Committee on the Law of Patents, but also as an organization, as the Secretariat, to deploy some activities that will be simply meaningful and simply useful for the users of the system. Now, we were very, very mindful not to step on anyone's toes. And there are 3 fundamental principles the SEP strategy is founded on. One is, of course, neutrality. So we are not taking sides. We are not favoring one industry segment over another, or one side over the other. And of course, we are not taking sides geopolitically. So it is neutral. Anything we are doing must be balanced. All the speakers at our events, all the authors of our studies, and all the viewpoints that are presented have to take into account every single aspect of the matters. So neutrality is the first. The second is the complementary nature of the strategy. That means that we are not trying to replace or compete with any regional or national policy measure that the countries are considering. We are not doing anything that would compel them to strengthen or abandon anything that they are doing. We are simply doing something that is building on top of it, and that is addressing some issues on international level where we can actually do certain things, leveraging WIPO's global reach and leveraging the global community that we are working. And the third principle that the strategy is founded on is the voluntary nature of the initiative. So we are not doing anything that would create a regulatory or an administrative burden on people. We are simply trying to enhance transparency. We are trying to put out as much information as possible and provide the platforms for discussion and, of course, also for alternative dispute resolution.
I would think that what you're going to be doing is trying to bring people together, though, right? I mean, because when I heard that you guys were going to do this and you're going to host a symposium coming up, which maybe we could talk about that here in a little bit.
Right.
My thought is, oh my goodness. I mean, because there's the way that the Europeans are doing it or trying to do it. There's a way that the Chinese seem interested. There's what's going on in the UK, and then the US is just different. It seemed like it's very needed to have in my words, and if you want to comment on this, an honest international broker to come together and say, okay, guys, we can't do it this way. I mean, standard essential patents are applicable, as you've already said, and everybody realizes across the world. There's not 5G in the US versus 5G in Europe. I mean, it's the same technology, but there's something so fundamentally important. We have such a variety of different ways that countries, and in the case of the EU, member organizations, really a whole continent almost, handle these issues. So are you going to be trying to pull people together, create best practices, talk about what's good and bad in a way that has been talked about out there? But when WIPO comes to the conversation, you guys have a lot more gravitas, I think.
Thank you, Gene. And I'd like to believe that people look at WIPO that way. And the fact that you are looking at WIPO that way, it's already making us happy. Yes, indeed. In one sense, we do want to create a platform for open discussion for everyone involved. On the other hand, of course, a symposium that we are going to organize, and I will address that a little bit later, it's not going to be much more than a conference, a big one, a global one, bringing together a lot of stakeholders. But we are not trying to impose any kind of rulemaking on anyone just by organizing this symposium. We are hopeful that bringing together a wider variety of people to talk about these things will eventually be conducive to solutions that will facilitate licensing and dispute resolution in this area. But it's still a symposium, so it's not trying to be a norm-setting forum. But we do believe in the power of dialogue, and we do want to make this symposium into something different from a regular conference over SEPs where people are just repeating over and over their known positions. And to this end, we are trying to pull together a very diverse set of stakeholders. We are not only inviting industry representatives, but we are also engaging with standardization organizations. We are engaging with policymakers, IP office people, judges, academics, and SMEs even. And we will also have a panel on SEPs and the global economy. And we are trying to also encompass jurisdictions or countries that might be emerging or might be even falling behind, understanding how the SEP licensing and SEP disputes are represented or not represented in those areas, and how the developing world is actually addressing these issues, or whether there are some loopholes or gaps that need to be filled.
How are you going to determine whether the symposium was a success or not? Do you have any preconceived notions at all about what happens after the symposium, like the day after? What do you hope the people are talking about, or what do you hope is the takeaway?
Right. Well, first of all, then let me put a promotion bit here. So it's September 18 and 19, and it's the first WIPO SEP Symposium. And because it's the year of IP and music, and because it's on SEPs, and it's in September, we call it September Symphony. So it's going to be a little bit musical. We are going to play some music, and we are going to, weave the power of music into the discussion. But this is the fun part of it. It will be successful if many people actually turn up. And why I'm saying this is that we took the risk of organizing it as an in-person event. There will be webcasting, but without, participation rights or asking questions online or commenting online. And if we do manage actually to get all those people into Geneva to have these conversations, that's already going to be a success. WIPO events with so many participants, we are nearing 500 registrants so far, are usually great networking opportunities. And we already see that certain member states and certain organizations and certain industry stakeholders are organizing their own events on the margin of the symposium. This is already a sign of success, because it means that this is going to be a milestone. This is going to be a major event for many stakeholders. And they do consider this as, like a watering hole for the SEP community.
Yeah, that'll be good. And it's impressive that you're able to do that on the very first time you're doing this, is because once you
let's hope for the best.
Yeah, because once you start getting things happening on the side, that's when real magic happens. And it's not to say that the symposium or conference or conversations there aren't going to be good, but I'm sure that they're going to be outstanding. based on who you're able to bring in and who the speakers you're able to get. But when people then leave and go and they have their dinners or their after parties and the conversation continues, that's really what you want when you're putting something like this together, is the conversation continuing. And
we're also, sorry, go ahead.
No. So that was what I mean. Are you guys going to come out with a paper or a series of papers after the conference, or are you going to publish any of the materials, or what foundation are you laying to try and make sure that this does continue and not just become a great conversation while we're there, but something that really has legs?
First of all, we will have a couple of side events that are organized with our facilitation regarding ADR and SMEs, and also regarding how to enhance the functionality that we have just recently put into patent certain designated SDOs. So we will have those smaller events that are linked to some initiatives that we are doing also under the strategy to make some progress on those respects, in those respects. But there will be, for example, also a panel that will present the preliminary findings, or a bit of a teaser of an economic study that we are going to come out with during this year on FRAND determination methodologies. So we gathered a group of very talented and very knowledgeable economists to put together an economic study on FRAND determination methodologies, a survey on what's out there without, again, taking sides, without ranking the different methodologies, just presenting what they are, what their advantages are, what their drawbacks are, and what are the contentious issues around them. And this study, even though it won't be published by that time, will already be presented in terms of findings at this event. Many of the deliverables under the SEP strategy of WIPO, I already mentioned the patent scope functionality, I mentioned the study. We also have the SEP case law collection in WIPO Lex. So these will be weaved into the program of the symposium. We will be talking about them. We will be promoting them, not for the sake of ourselves, but to get them known in the community and to enhance the transparency in the field, because all this serves the purpose of providing more resources, more information. And we do believe that this will lead to more conversations. To your question about whether there will be any kind of a summary, there is, of course, a conference summary that is coming out after WIPO events. And I am just in talks with the editor of the WIPO magazine, and we are also going to have a feature there, which is not just going to be like a formal report of what happened at the symposium, but it will build on the outcomes of the symposium and give a bit of a flavor of what's coming next.
I'll put the bug in your ear if you guys want to publish anything on IPWatchdog after the event and let people know how it went. That'd be fantastic. Oh, you guys are always welcome to publish on our platform. I love what WIPO does. I really am a fan of WIPO, as you know. I don't just say that. I think
thank you.
WIPO is really essential. And I don't want to get you in trouble. I don't want to force you to try and take a position. But the issue of FRAND, I'll say this and see if you want to comment on it, is one that has always frustrated me. Because, and I'm kind of taking a long pause here because I almost don't know what to say, because the frustrating part about it is it seems like it should be such an easy, simple concept. What is a fair rate? Now, I understand there's a lot of variables, like the term of contract, how many units, or just a couple of the variables, right? Geographical scope, where are you going to use it, all kinds of things, right? So, but even as complicated as that is, there ought to be a calculation, or at least a range that everybody can agree on. What I think really confounds it, and you've mentioned this word several times already, is the lack of transparency. And I understand when you're doing business with somebody, you don't want all your business dealings out in the open and in the public. So a lot of these agreements wind up being confidential. But then it seems like both sides use the lack of transparency against the other side. And I guess when you're negotiating, you use everything that you can. But it seems like it just gets in the way. The lack of transparency, really, if I had to put my finger on the problem with SEPs, that's it. Because if you pull back the curtain, then we could argue about whether we use this approach or that economic approach. But frankly, I think they would all converge on a pretty narrow range, which is not what happens today. And So so a lot on the table, and I put a lot on the table so you can pick and choose whatever you think is safe. Because I know you guys at WIPO really do honestly approach this and want to be an honest broker and don't want to put your thumb on any particular scale. But can you talk to us a little bit about what you hope to see moving forward on the transparency issue?
What you said, I cannot disagree with that. It's a bit of a crystal ball. It's definitely not an exact science, even though it could be and probably also should be. I mean, FRAND seems to be an easy concept because it's fair, reasonable, and non-discriminatory. But when people start to argue about reasonableness, that usually ends up in very, very distant ends of any spectrum. What I hear from actual economists and also negotiators from companies, they usually admit to the fact that economics are only the starting point, and then it becomes a negotiation, bargaining, basically. Mm-hmm. And what they reach at the end might be, and ideally it is in the FRAND range, but it's not something that you can meticulously and mathematically prove that this is definitely in accordance with a certain definition of FRAND. It's going to be applicable between those parties as the outcome of their negotiations. And this is where it becomes difficult, because when you then, in the next negotiation, try to use or try not to use the previous negotiations because of the comparables method, then you can use it as an argument or a counter argument. You can distinguish it from the next negotiations, or you can say, no, actually, this is the same type of situation. But there will always be arguments and counter arguments, because the comparables are never really comparables, because no situation is identical to the other. So what seems to be something very simple will always end up being heavily dependent on the behavior, the good faith or bad faith of the negotiating parties. And that's where usually parties end up at court, where their positions on what FRAND is so significantly different, even though in theory they should be using the same economic principles. So I cannot give you an exact answer to that. I think my response to your question is that it is very difficult because the underlying principles are simple. I wouldn't even say that the economic factors are immensely difficult that no person can understand it. But when it comes to negotiation, there are so many other factors to be taken into account that it ceases to be an exact science. And then it really becomes something of some kind of a game theory scenario between the parties.
Yeah. And I think the thing that frustrates me is that there seems to be the possibility to have a starting place where everybody agrees. And I understand. So then maybe I used to write computer code. So a lot of times I think of these problems in code as if this, then that, if that, then this. And it seems to me like if we had a starting place that everybody could agree on, and I think in my head, you could write a program to figure this out. And then I also wonder now, with AI being so omnipresent in everybody's minds and trying to find solutions to really difficult problems, whether AI might be a solution for this moving forward. But it seems to me that there is a formula that gets you, and if not to a number, I do think it can be a number. And I know my friends in the economic world tell me, no, FRAND is not a number. No, I get FRAND is a concept, but at the end of the day, as a business person, if you come to me and you're trying to sell me something, my first question to you is going to be, how much? Because you might have the greatest thing in the world, something, I can see how we could use that. We probably really need it, but if I can't afford it, I can't afford it. So at the end of the day, it is a number that you come to, and it seems to me to be a process, multi-factor, like three-dimensional calculus, multivariable calculus kind of problem to get to that number. But it seems to me like it's a math problem. Or because it's relationships as well, negotiations and all kinds, but that can be translated into code or into math to figure these things out. And that's why I just get kind of frustrated. And again, a lot on the table there, but maybe the safe thing for you to answer might be about, have you thought about the use of AI in making these determinations? And is that something that you're going to maybe talk about at the symposium?
I think it would be very premature to use AI for that. And also, WIPO as an international organization is not determining FRAND. So we are not adjudicating disputes. Of course, there are the alternative dispute resolution mechanisms, but that's under confidentiality, and that's with the participation of a WIPO neutral who is helping the parties to mediate or by arbitration or even by expert determination. So there are parties who can come to WIPO and say, we only need some kind of an answer to this narrow question, not all our dispute. And then WIPO can procure a neutral person who can determine that. So only in this sense, WIPO is actually a determining FRAND. In other ways, we are not doing that. We are not the arbitrators of that. But we do have to increase the transparency that has been mentioned several times now, because what you mentioned as a mathematical formula or something that could be automated, the hindrance is that there are so many variables that the parties can pull out of the hat to say, yeah, but look at this. I mean, there is not even an agreement globally what should be the right base or the right place in the value chain where licensing should happen. And, wherever you put that dot on the scale, that will inevitably determine or influence rather what the end result is. And there are so many things that the parties can argue with using the different methodologies, whether it's top down, whether it's comparables, and to what extent they do disclose what what kind of agreements they reached with other parties. That I think is just, on the one hand, lack of information or information asymmetry, if you like. And on the other hand, a lot of information that is out there, but it's undigested, it's raw, such as the Essentiality declaration, because that's also a variable, that's also an uncertainty factor that, okay, I have a huge portfolio of patents that are declared as essential, but in the absence of a trustworthy and cost-effective mechanism of actually determining or assessing whether they are essential or not, it will be very difficult to say whether that whole portfolio should actually be licensed or not for the implementation of that standard. I don't think that the underlying concepts are the ones that are being disputed, because everybody claims that they are within the FRAND range. It's rather the variables around them that heavily influence what the end result is. And that is why parties, in some cases, find it difficult to come to an agreement.
Yeah. Yeah. And I guess I will admit that I forgot about the whole issue about the self-declaration and what actually is a standard, because that does really influence. And and that's something that I do think maybe, I know there are people working on it now and have had some solutions out there for a while that are pretty good. And I think they're only going to get better, that where you can look at a portfolio and you can look at the standard and you could say, hey, well, you might have 40,000 patents in your portfolio, but only 5 or maybe 10,000 of them actually are quote unquote essential. And that's, see, I almost think that we need to come up with different language or different terms, right? Because what I just said is not accurate, because they're essential because they've been declared and because they've been put on the table. They're not essential because they actually find themselves into the standard. And I think is a place where there's a lot of ships passing in the night, because I can understand from the implementer's perspective, I understand you have 40,000 patents. The standard that I'm using uses 25% of those. I don't want a license to all of them. I want a license to the ones I'm using.
It's one of the big questions.
It is a huge question. And that to me makes a lot of sense now. But then from the innovator side, well, I had to lay all these out on the table. I had to say that you can use them. Yeah. And it based on a promise that I was going to get paid for that. And there's always gaming on both sides. And that's, I think, what really causes this to unravel, and probably why courts need to get involved in this area more so than probably any other area in our industry, because the courts usually can set the rules and then people figure, okay, well, that's the rules. This is, and when in the US, we've had some problems with that, because I think that we've kind of gotten sidetracked and not let people know enough about what the rules are, that you force people into the court system. And I've been a big critic of that. And I think that fundamentally is probably the thing I dislike about standard essential patents the most, with all the uncertainty, with the lack of transparency, with different concepts of what is and what is not standard. it forces people to litigate. And I just think that's the wrong place for the law. I think it works best when people they're arbitrating or they are mediating, or like you were saying before, mediating the certain issues that matter or arbitrating the certain issues that matter, and then getting an answer to that and then making the decision to negotiate. Right. I see in this space, there's almost feels like a frustration that's caused by needing to constantly go to the courts.
And I think your frustration illustrates very well why we actually stepped into this arena. And I think it couldn't be a better way of explaining it again from another angle. So there are all these uncertainties and like dark corners of SEPs. We are trying to just shed some light with a torch into these corners. So we say, okay, are you curious what are the most noteworthy kind of policy advising cases in a certain jurisdiction about this? Look at the case law collection. Are you curious what patents in our patent scope database have been affected by an essentiality declaration at one of the SDOs that are working with us? Take a look at this new tab in patent scope and it flag you that this is potentially a standard essential patent because it has been declared. We are not saying that it's truly essential, but we say that they are featured in the SDO databases and we want to create a one-stop shop to give a heads up to people who are consulting patent scope. Or are you curious what are the economic underpinnings of the methodologies that the courts, the parties, the patent pools, and so on are using to come to some kind of a FRAND compliant licensing term set? Then this is the study for you to understand the science behind it. So these are the types of things that we are trying to do. And of course, with the symposium, we are trying to bring all the people together to be able to talk about these things. So this means that whatever we are putting out is not something that compels people to do anything, but it might enhance their understanding of these issues. And it might contribute a little bit to dissipating the obscurity around these concepts.
Yeah. Well, anything you guys can do that does that, I think will be a success. And I appreciate you taking the time to chat with us about this today. And just quick, we'll throw out the dates again. They're September 18 and 19.
September 18, 19 in Geneva. Yes. And it's free of charge. So there is no registration fee. And I'm inviting everybody and anybody to check out the website and register and come to Geneva to talk with us.
Yeah, we'll make sure we post the link to the website. And if you can't make it to Geneva, although you won't be able to participate in the conversations, you will be able to watch it. It'll be webcast, exactly. Which I'm sure will get a much larger audience as well. So I wish you luck and I congratulate you on getting into this area. One last question before I then give you the microphone for your final thoughts here would be, is this something that you see becoming a yearly conference? Is this going to be every other year? Or are you going to wait and see what happens here? Or and that may be not a fair question because you're just jumping into it. And I know you've got plans for the rest of this year and next year, but if you had to look into your crystal ball, what do you think is going to happen?
What is for sure is that this is not the last time that we are organizing something, but knowing the other things that we are doing and knowing how much organizational efforts are going into this, I can quite confidently say that it's not going to be a yearly event, but we will build on it and we will organize, I think, smaller events around certain thematics or themes that are identified through this. And we will also partner up with other organizations, WTO or others who have some kind of a stake in this to make sure that we can target certain issues and we can get a more niche audience for one aspect or another. So we are going to organize more events, major global symposia, maybe every other year or every third year. I cannot promise anything, but surely not an annual event.
Yeah, but that's the WIPO model, right? You have a big event, then you figure out what do people want to talk about, what needs to be talked about, and then you hone in on that. Then after a little bit, then you bring everybody back together again.
Yeah, exactly. That's the idea.
Awesome. Excellent. So any final thoughts before I let you go about this or anything else that you're working on, or just how are you doing since we last spoke?
I'm doing very well, thank you. Right now, I'm in Budapest on holidays, but Geneva is, of course, very busy. Apart from SEPs, we still do a lot of things about trade secrets. I can only mention again the trade secret guide that we have put out. It's a very useful material, and I was very lucky to be able to talk about it last time we met. We are transforming that actually into a distance learning course now. So if somebody doesn't want to read the 200-page document, they, from next year, when it's done, they can also take the course at the WIPO Academy and learn everything that's in the guide. And also on trade secrets, we are building up a trade secret case law collection similar to the SEP one. So this is a model that we are going to move forward with and replicate the collections with other areas. And of course, in November, we will have the Standing Committee on the Law of Patents, which is our now annual big event for all the member states to come together and discuss the issues that they would like to address.
Well, that's great. When I first started doing this with IPWatchdog back in 1999, there was days I would sit and wonder, what am I going to write about today? Because there was not all the movement, all the interest that we have today. And now a lot of times I sit back and say, okay, what am I going to write about today? Because there's so much going on.
Exactly.
It's an exciting time. And I really appreciate you coming here and being, particularly taking yourself away from holiday to be here. And I look forward to this symposium, and I look forward to our next conversation.
Thank you so much, Gene. It was a pleasure.